immigration consultant for GSN Immigration, and I am an OISC registered level 3 advisor. If you haven't subscribed to our channel, please do so and click on the bell icon. Today I'm going to talk about visitor visas and visitor visa refusals. What is a visitor visa? Well, it can be all sorts of different things. It can be a visa to come to the UK to do some tourism, to see the sights, Madame Tussauds, Buckingham Palace, all that sort of thing. It could be a visa to come and visit your friends or your family. It could be something a bit more specialised. It could be a visa to come to the UK to do some sort of peripheral business work, having meetings, signing contracts, advising, attending seminars, something like that. A visitor is not allowed to work, but they are allowed to do peripheral business activities of this kind. There are other types of visitor visa. In fact, there are loads of different kinds. I'll just mention maybe one more. You can come to the UK for private medical treatment. You can come to the UK to get married in the UK. There are lots more types as well. Those are some of the main ones. Typically, a visitor visa is for 6 months or less. There are some visitor visas that can be extended to a longer period, but most of them can't. You can apply for a 6-month visitor visa. Confusingly, you can also apply for a 2-year visitor visa, a 5-year visitor visa, and a 10-year visitor visa, but this does not mean you can come to stay in the UK for 2 years, 5 years, or 10 years. What it means is you can come and go from the UK within those time periods, but there is a rule, very, very important. You shouldn't be spending more than half your time in the UK if you're here as a visitor. This isn't something actually in the immigration rules, but it's a rule that exists somewhere up there. If you're a visitor, you should be spending less than half your time in the UK. If you're a visitor, your main home should not be in the UK. Your main home should be somewhere else. Now, if you're spending more than half your time in the UK, it looks very strongly as though your main home is in the UK. So this really isn't going to work. It's probably going to get you into trouble. Visitor visa, visitor leave is for people who want to come and go for shorter periods or longer periods, but it's a very, very good idea if you're on visitor leave. Don't stay in the UK for more than half your time, and if you're very wise, don't stay in the UK for something nearly approaching half your time. It's best to spend just a few months per year in the UK if you have one of these long-term visitor visas. Otherwise, it could lead you into trouble in the future. If you apply for a new visitor visa, you may find that your application is refused because the immigration decision makers will look at your past history. So visitor leave is for people who want to come to the UK for visits, not making the UK their main home. Now, if you come from a country like USA, Australia, New Zealand, Taiwan, Brazil, somewhere like that, you don't need to apply to the UK immigration authorities for a visitor visa. You can just come with your passport to the airport, say, I've come as a visitor, here's my passport. Hopefully, they will let you in. If you come from a different kind of country, mainland China, India, Pakistan, somewhere like that, you do need to apply for a visitor visa before you can come to the UK. You won't even you shouldn't be able to get on the airliner without a visitor visa. You can come to the airport in the UK, show your passport with your visitor visa, and then again, hopefully they will let you in. There are some complicated rules and scenarios about this, but the basic idea is if you've got a visitor visa or you've got a passport from a country which is a non-visa national country, immigration control, they should let you in and say, welcome, please come and enjoy yourself as a visitor. The rules are supposed to be the same for these non-visa nationals, people from America, Australia, Japan, so on and so forth. The rules are supposed to be the same for non-visa nationals as they are for visa nationals, but of course the process is very different. If you apply for a visitor visa, the process is different. It is an unfortunate fact. Sometimes visitor visas are refused. Visitor visa applications are refused. In some countries, the rate of refusal is very, very high. Maybe some countries are better than others. I know from my experience, visitor visa applications from Iran, very high refusal rate, quite high I think from India, Pakistan, Asian countries. There is a chance that your visitor visa application is going to be refused, and sometimes the reasons for refusal are strange or silly. For example, one of the things you have to show, you have to prove when you're a visitor, you've got enough money to support yourself. You've got enough money to book a hotel. If you're going to stay in a hotel, you've got enough money to spend in the shops. You've got to have enough money to pay the airfare, pay the return fare. Some people book the flight before they apply for the visitor visa. That's not a good idea. It's better just to have the money in the bank, have enough money to pay for everything. Sometimes a refusal decision says, well, you've got plenty of money in your account, but we don't know the origin of the funds. We're not satisfied that this money is really yours. You get funny things like that. Another reason could be, we don't really think that you're a genuine visitor. You haven't got much family in your home country. You've got quite a lot of family members in UK. We think maybe you're not going to come back. You're going to be happy with your family members in the UK and you don't want to go back. You've got a daughter who's just had a baby, and you say, I want to visit my daughter and see my new grandson. They say, but probably you're just intending to come to the UK to look after your new grandson. All these sort of things can happen. This is a very important issue with visitor visa applications and indeed visitor visa application refusals. Are you a genuine visitor? Do you really intend to come back, go back to your home country or not? This is something you have to think about. Visitor visa application, it looks easy. If you read the Home Office website, it looks easy. A lot of things can go wrong, and especially so in some countries, perhaps more than others. Anyway, the application is quite cheap as visa application goes. 6 month visitor visa is just £95, although this will be converted into either a local currency or US dollars, and the conversion rates are not very good. But even so, 6 month visitor visa, the application is quite cheap as visa applications go. 2 year, 5 year, 10 year visitor visas, they are more expensive. They become more expensive as they get longer and longer. But in a general way, visitor visa application is quite cheap. You might think, well, I haven't got much to lose, I haven't got so much money to lose if it gets refused. Well, I would be cautious about this, because if you have a visitor visa refusal on your record, it makes life more difficult if you want to try again, because you have to fight against the previous refusal. You have a sort of a black mark on your record that you have to overcome. You can do it yourself. You might want to instruct a lawyer, but it's up to you. But it's important that you understand all the things that can go wrong, as I've just tried to explain. Processing for visitor visa application is quite fast. Probably you're going to get a decision within 1 or 2 months. As I say, you might get a refusal. Or if you're a non-visa national, you might get refused leave to enter at the airport. They might say to you, well, we don't think you're a genuine visitor. It depends how busy they are that day, but they might stop you, say, who are you coming to visit? I'm coming to visit my uncle. Sometimes they take your uncle's phone number and ring them and say, hello, this person, are you his uncle? They might ask how much money you got in the bank. Things can go wrong with visitor visa applications or at the border. If you're from a non-visa national country, you can apply for a visitor visa. There's no rule that says that non-visa national can't apply for a visitor visa. You can. And you might want to, if you've had previous problems or issues with immigration, you might want to do that. If you have got a visitor visa, the chances of getting into the UK should be quite high. However, it's not automatic. If you hold a visitor visa, it doesn't mean you automatically get let into the UK. You still might be asked questions, but you've got better chance. But if the immigration officer at the airport establishes, or think they establish, that you're not really coming as a visitor, for example, this is something that I've seen happen a few times. Someone comes and they go through the luggage. They're allowed to do this. They're entitled to do this. They find you've got loads of copies of your CV in your luggage, and they said, "But you said that you were coming to visit your uncle, but you've got all these CVs in your luggage. How does that work?" Because they think that you're coming to apply for jobs and possibly to work. Because, as I said, working is illegal. It's against the rules for a visitor. Peripheral business activities are acceptable. But working is not legal. I don't think that looking for jobs is actually illegal, but it doesn't look good. If you're coming saying you're coming to visit your uncle and you've got loads of CVs in your luggage, it doesn't look good. It looks as though you're thinking about working. All these things can go wrong. If you get the refusal, what can you do? Can you fight? Depending on the reasons, you might want to fight, you might not want to. If you've been accused of something dishonest, deception, something like that, you really might want to fight because you want to get the allegation of deception, dishonesty off the record. If you fight successfully, then that allegation can be removed. If it's for something more trivial, you might not want to fight. You might just want to make a fresh application or instruct your favourite lawyer to make a fresh application and try and avoid the problems that emerged from the previous refusal. Important question: what are the remedies for visitor visa refusal? A lot of people might tell you that there is no right of appeal to the first tier tribunal if you have a visitor visa refusal. Probably in 95% of cases this is correct, but it's not always correct. If you come to visit spouse, civil partner, and you're refused a visitor visa, you might have the right of appeal to the first tier immigration tribunal because this is deemed to be a human rights application. If you come to visit your minor child, or if the minor child has applied to come to visit their parents and the visitor visa application is refused, they might have the right of appeal to the first tier tribunal because this is deemed to be a human rights application. So in these cases, which are like to be a probably quite small minority, there is the right of appeal to the first tier tribunal if you can convince the first tier tribunal that it was a human rights application, and probably partner visiting partner, parent visiting minor child visiting parent, then probably it is a human rights application, and indeed there might be right of appeal to the first tier tribunal. However, appeals take an awful long time at the first tier tribunal, but at least the avenue of challenge exists in that way. Everybody knows that appeal is a good way of challenging something, although it takes a long time. It's a good way of challenging something. First tier tribunal is presided over by an immigration judge who's a qualified lawyer who understands the law, who is not employed by the Home Office. They have a solemn duty to make a fair decision. In the majority of cases, there is no right of appeal, and visitor visa refusals do not carry the right of administrative review, unlike lots of other types of visa. If there is no right of appeal, your only recourse to legal challenge is judicial review. Judicial review is a big subject. I'm not going to give a complete explanation because we haven't got all day and all night, but I would like to tell you the starting process for a claim on judicial review is that you, or perhaps your lawyer, writes a letter to the Home Office, which is called a judicial review pre-action protocol, sometimes referred to as a letter before action. It's a letter which threatens judicial review proceedings before the upper immigration tribunal. The upper immigration tribunal is the higher tier of the tribunal. The first tier tribunal is the lower tier of the tribunal. The upper tribunal hears judicial review applications. Judicial review is a process whereby a senior tribunal or a court reviews a decision made by a government decision maker, such as the Home Office, such as UK Visas and Immigration. It reviews the decision to see if the decision was arguably wrong, arguably unlawful, arguably procedurally incorrect. The word arguably is important. The court or the tribunal doesn't have to be totally convinced that the decision was wrong, but they have to feel that it might have been. If you can convince a tribunal that the decision was arguably wrong, you can do judicial review with that court. However, as I say, the starting method is to write this letter, or your lawyer write this letter, Judicial Review Pre-Action Protocol, commonly abbreviated JRPAP. This is a letter not to the tribunal, but to the UKVI. In fact, it will be sent to the Home Office in UK to say that your visitor visa has been refused. You think the refusal was wrong, unlawful, unfair, procedurally incorrect, something like that. You write this letter to the Home Office, say, we want to challenge the decision. We're asking you to change your decision. If you don't change your decision, then we are thinking of applying to the upper tribunal for judicial review. It's a threatening letter, pretty much. Important thing is, though, this is not a threat that you have to carry out. You give the Home Office, the UKVI, you give them the opportunity to change the decision. You present the arguments as to why you say that the decision is wrong. Sometimes it works. I mean, sometimes decisions are wrong. Sometimes the decision makers don't look at the documents properly. Sometimes they seem to be completely unaware of some of the documents that were sent. Sometimes their maths is wrong. Sometimes they work out that you don't have enough money to do this and that, and they use the wrong conversion rate, or they make mistakes with their maths. Things go wrong. Everybody knows that entry clearance officers in British consulates, British embassies, British high commissions, they work at tremendous speed. They don't have enough time really to consider applications properly. It certainly looks that way at any rate. They sometimes make a lot of mistakes. Sometimes a visitor visa refusal is obviously wrong, obviously unfair. Sometimes they seem to get completely mixed up. Let's say you've got many family members in your home country, you've got a couple of family members in UK. Sometimes the entry clearance officer says, you haven't got strong ties to your home country. Probably they just haven't read the papers properly. Anyway, if you think you have a strong case, or ask your lawyer, does your lawyer think you have a strong case, they can prepare Judicial Review Pre-Action Protocol, send it to the Home Office in UK to challenge the decision, say we think the decision is wrong because of this, this and this, and you invite the Home Office or UKVI to overturn the decision and make a positive decision. Sometimes it works. If it's prepared professionally, strongly, punchy, sometimes it works. This is quite high-level, difficult work. You might want to instruct a lawyer to do it, but if your lawyer thinks you've got a strong case, this might be a good avenue. You don't have to challenge the decision. You could make a fresh application. It's up to you pretty much. Your lawyer should explain to you about the two options, about the advantages and disadvantages of both. That was my piece about visitor visas and visitor visa refusals. Please click on part 2 when I shall be answering some of your questions.